Hello and welcome to day 4 of the mock trial. The trial is coming to an end, and today you will hear closing arguments from the plaintiff and defense. At the end of this video, you will see a link to submit your verdict on this case as our mock trial juror. In the same link, you can also submit questions to our attorneys and risk managers for discussion on Friday at noon during our live Q&A session.
May it please the court, Madam Forelady, members of the jury, the case is now at an end. It's going to be presented to you to make the decision in this case to address what has been undoubtedly a tragedy that destroyed this family, a tragedy that took Miss Williams from her daughter at much, much too young an age. Now, unfortunately, you've been forced to learn a lot of medicine in this case, and hopefully we've done our job to sort of simplify the issues and show you where the ball was dropped time and time again. You know, I use sports analogies because I grew up playing sports and my kids play sports, but when you drop the ball this many times, bad things happen. In sports, you lose the game. In medicine, you lose a life. And that's what happened here. I want to talk to you, thank you, Mr. Miller, a little bit about what I believe the evidence has shown. We know from the timeline that Miss Williams arrived at 9:30 a.m. We know that the people including Dr. Lewis at Prince George's Hospital, didn't order a single radiographic study of any kind until after Miss Williams began displaying overt signs of stroke. I mean, everybody knows if you got the face droopiness and the arm droopiness, you got a stroke. What healthcare providers know that maybe we don't is that signs of dizziness, rapid heartbeat, those too are signs of strokes. You just haven't gotten so bad that you can't move an arm or droopy face. We knew from Dr. Gaynor, a board-certified emergency room physician who came in and told us that is a sign of a stroke. 9:30 a.m. We should have been ordering studies. We should have figured out this was going on, and we should have had my client's mother at a place where she could have gotten care earlier. That was the first breach of the standard of care. That was the first fumble. Now you could say, well, that was a subtle sign. Maybe it was okay that they missed that. But what's not okay is to have what everybody agrees is signs and symptoms of a stroke at 2:00 p.m. and then sit on Miss Williams and not get her to where she can get care for 7.5 hours later. As Dr. Gaynor told us, as your policy from Prince George's County Hospital makes clear, that is too long. Time is brain. And the delay in this case took the client's brain, ultimately causing her death. Now you're going to get a verdict sheet at the end of this case, and the first question is going to be, did Dr. Lewis breach the standard of care? Delay, 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 fumble, fumble, fumble. The answer to that question is yes. Now the second question I find very curious, that the defense says, well, this is a bad clot and bad things happen with these clots. Well, sure they do. But if they're treated timely, patients have a chance of recovery. I heard the doctor from Brigham and Young's talk about it's rare that these patients do well. Well, who are they to take that chance away from Miss Williams? It's not Dr. Lewis and his team's right to deny Miss Williams the opportunity to be one of those rare ones, to be alive, to be timely in this world with her family now. So they don't get the benefit of the doubt that this is a tough clot, and when you delay, you make it worse. So the answer to the second question, if they had gotten timely care for Miss Williams, would she be okay today? Give her the benefit of that doubt. The answer to that question also is yes. Standard of care violation caused my client's death. Those are the easy questions in this case, honestly. The hard question in this case is, what's the economic value of that? What is the financial value of that? And that's where the jury system in this country is where you make your living. That's the hard part of this case. What's a fair value for taking a woman's life from denying a daughter her mother, the grandchildren, their grandma? What's the fair value of that? That's something that you're going to have to decide. I'm going to throw out a number. You can make it bigger, you can make it smaller, but I have an obligation to my client. And I think $1 million is a fair number for this case. But I'll tell you this. If you ask Layla Williams, did she want $1 million or does she want her mother back? You know the answer to that question. So when you go back and deliberate, please be fair to my client. And I appreciate your patience through this case, and I know you've been paying attention. I watch everybody making notes, and we look forward to your verdict. Thank you.
Ladies and gentlemen of the jury, you've been very attentive throughout this process, and I wanted to thank you for your time and attention to this matter. Very important to both parties, and I just wanted to thank you for that. And now, it's time for you to deliberate and for you to decide. Was Dr. Lewis negligent? Did she commit medical malpractice and cause the death of her patient, Miss Williams? I suggest to you the answer is no. By now, you've heard a lot about Dr. Lewis and her care of her patient, Miss Williams. You heard directly from her, and you heard why she did what she did in caring for her patient that day. And I believe that you saw, as I did, that she is competent, experienced in treating patients like Miss Williams suffering from stroke, and she cares deeply for her patients. I want to tell you a little bit about Maryland law in this case, ladies and gentlemen. It is the plaintiff's burden of proof in this case. They have to prove to you by a preponderance of the evidence, more likely than not, that Dr. Lewis was negligent, that she was unreasonable, and that she caused the death of her patient. I suggest they did not meet that burden. We talked earlier in the week about the two questions that you needed to think about as you heard the testimony in this case. The first question, did Dr. Lewis commit malpractice? Was she unreasonable? And two, did Dr. Lewis cause Miss Williams' death? You have to believe both of those things are true in order for plaintiffs to prevail in this case. If you find, ladies and gentlemen, that Dr. Lewis did not commit malpractice, if you find she was reasonable in her care of Miss Williams, plaintiffs did not meet their burden. Likewise, even if you find that Dr. Lewis was unreasonable in her care of Miss Williams, which I do not believe you will find, but even if you find that, if you also find that she did not cause her death, again, plaintiffs did not meet their burden. So what did Dr. Lewis tell us when she testified earlier this week? She told you that she evaluated Miss Williams multiple times throughout the day, providing care for atrial fibrillation, and then when there was a change in condition, providing the stroke assessment and treatment and getting her transferred as soon as possible. She called a code stroke immediately as soon as there was any signs or symptoms of a stroke, and she worked hard to get Miss Williams transferred as quickly as she could. Because of her care, Miss Williams had a chance. Let's talk a little bit about that first bridge. Was Dr. Lewis's care reasonable? The answer is yes. Dr. Lewis evaluated Miss Williams and properly confirmed she was in atrial fibrillation with RVR and treated her for that condition. She evaluated Miss Williams numerous times for stroke using the NIH stroke score and neurological assessments, all of which were negative, not indicative of a stroke. As soon as there was a change in condition, again, Dr. Lewis is back and evaluating Miss Williams, and she recognizes that this is a possible stroke presentation. She quickly jumps into action. She calls a code stroke, she orders a stat head CT, and she calls an on-call neurologist, the specialist in this area, for a consult. All appropriate, all reasonable, all within the standard of care. What did we hear from Dr. Gaynor, plaintiff's emergency medicine expert? Dr. Gaynor tells us dizziness alone with a normal NIH stroke score. Call a code stroke, even though she doesn't even do that at her hospital. And ignore an NIH stroke score that is completely normal. Ask yourself, is that fair? Is that reasonable to judge Dr. Lewis by those standards? As confirmed by Dr. Van Horn, the Harvard emergency medicine expert, Dr. Lewis exceeded the standard of care. There was no stroke upon presentation. Dr. Lewis treated her appropriately for the conditions that she had. As soon as there was a change in condition at 2 o'clock, Dr. Lewis called a code stroke immediately, obtained the appropriate studies and consults, and transferred Ms. Lewis as soon as she was accepted. All very reasonable, all within the standard of care. And for that reason, ladies and gentlemen, I believe that you will find Dr. Lewis did not commit malpractice in this case, and plaintiffs cannot prevail. Now, you only get to the second question here if you find that Dr. Lewis was unreasonable. I don't think you'll get here, but I do want to talk a little bit on the causation piece, that second bridge. And this time we're asking ourselves, did Dr. Lewis cause Ms. Williams' death in this case? And the answer again is no. Ms. Williams had a large clot in the back of her brain. This is a devastating injury to the brain with a very grim outlook. It is considered a brain catastrophe or a bullet to the brain. It's associated with high fatality rate, even when clot retrieval is accepted, like here. So if Dr. Lewis did not cause Ms. Williams' death, what did? It was that clot, that brain catastrophe, not Dr. Lewis. And for that reason, even if you find that there was malpractice, ladies and gentlemen, you cannot find that Dr. Lewis caused the death of her patient, and plaintiffs still cannot prevail. Now, we talked a little bit earlier in the week about sympathy. This is certainly a sympathetic case, and I know you all feel very sympathetic for the family, as we all do. But please, as you're deliberating, take that sympathy, put it in a box before you go into those deliberation rooms. Because what you're deliberating on, ladies and gentlemen, is the care that Dr. Lewis provided. Make your verdict about Dr. Lewis's care, not the sympathy that you feel from Ms. Williams. Ladies and gentlemen, Dr. Lewis is a very caring physician, and this is very important to her. Please, in your deliberations, tell Dr. Lewis she did not cause the death of her patient. And I'm asking, return a verdict for Dr. Lewis. Thank you.
Ladies and gentlemen of the jury, I thank you for your diligent attention and careful consideration throughout the course of this trial. Your role is vital in ensuring that justice is served, particularly in cases as complex and significant as this one, involving allegations of medical malpractice. As you prepare to deliberate, I must remind you of your responsibility to weigh the evidence presented objectively and without bias. Your decision should be based solely on the facts as they have been established in this courtroom and the law as I instructed you at the beginning of the case. Remember that the burden of proof rests with the plaintiff to demonstrate by a preponderance of the evidence that the defendant failed to meet the standard of care expected of a reasonable medical professional, and that this failure directly resulted in harm to the plaintiff. Consider each witness's testimony, any exhibits admitted into evidence, and the arguments presented by both sides. Arguments are not facts, but they are for your consideration. Pay close attention to any expert opinions offered regarding the standard of care and whether or not it is breached. Ultimately, your task is to render a fair and just verdict based upon the evidence and the law. Your decision will have an impact on the lives of the parties involved, and I trust you will approach your decision with the seriousness and integrity that decision deserves. I commend you for your service to our system of justice, and I trust in your ability to fulfill your duty with wisdom and impartiality. You may now retire to deliberate. When you have reached a unanimous verdict or a decision upon which all of you agree, you may return to the courtroom to deliver it. Again, thank you for your service.
As the judge told you, now that you've heard this case, we are asking you as a mock trial juror to submit your verdict using the link below. Obviously, you won't be formally deliberating as a group, so please proceed with sharing your decision about the trial. We look forward to seeing you tomorrow in our live session at noon for further discussion. We will reveal your verdict as well as the outcome of the actual trial. You would also hear from our attorneys and have an opportunity to ask questions.